Hi, this is Ramya Ravindran and welcome back to my channel Infinity for UPSC. And today we are going to cover a topic called Ordinance. I have taken up this topic Ordinance because in the previous lecture of Parliament we had discussed something about Ordinance. So I thought that I would take up this topic and cover it in detail. So the first and the foremost thing that you need to know about Ordinance is the article associated with it. It is Article 123. Very easy to remember. Article 1, 2, 3. Article 123 is associated with Ordinance. So this empowers the President to promulgate. That means to issue Ordinance during the recess of Parliament. So here they are saying that when the Parliament is functioning, President cannot issue an ordinance. He can issue an ordinance only when the Parliament is not functioning. These ordinances have the same force and effect as an act of Parliament but are in the nature of temporary laws. While discussing about Parliament, I have already mentioned this topic that there is no difference between a law and an ordinance. They are one and the same. The only difference is that ordinance is temporary in nature. They cannot exist for a long time. They either need to be approved by the Parliament and made it into a law, or they will decide to discard it. So one of these should take place because the ordinance cannot keep on existing forever. It is temporary in nature. The ordinance making power is the most important legislative power of the President. We know that legislation means making law. An ordinance is nothing but a law which is temporary in nature. And who is making this law? It is not the Parliament, it is the President. And why has this power been given to President? So that he is able to deal with any unforeseen or urgent matter that can take place anytime. But the exercise of this power is subject to 4 limitations. So we will have a look at each and every limitation of ordinance. First is, he can promulgate an ordinance only when both the houses of Parliament are not in session or when either of the 2 houses of Parliament is not in session. I have already told you that an ordinance can be issued only during the recess of Parliament. Now Parliament means it includes Lok Sabha and Rajya Sabha. So that means both the houses are part of Parliament. And when both the houses are functioning, an ordinance cannot be issued. But it can be issued when only one house is operating. Why? Because only one house do not constitute the Parliament. Parliament means both the houses plus the President. So in order to promulgate an ordinance, either both the houses of Parliament must not be in session or either of the 2 houses must not be in session. Now here they are giving an explanation why an ordinance can be issued when one of the houses is in function. An ordinance can also be issued when only one house is in session because a law can be passed only when both the houses are in session and not by one house alone. I have already told you that the idea or the proposal will arise in the mind of one of the member of one of the house and he will discuss it with other members of that house, and when that house passes the bill, it is transferred to another house and there also it needs to be passed and then it will go to the President. So here they are discussing the same thing. A law can be passed by both the houses and not by one house alone. An ordinance made when both the houses are in session is void. Void means invalid. That is, it is invalid in nature. Thus, the power of President to legislate by ordinance is not a parallel power of legislation. What is the meaning of parallel power? That means 2 cannot function at a time. Here Parliament is making a set of laws and here President is also making his own set of laws. That is not allowed. When the Parliament is not functioning, only then President is allowed to make an ordinance because there is some unforeseen or urgent matter which needs to be dealt with immediately. And that is the reason he has been allowed to promulgate an ordinance and not because he has been given a parallel power of legislation. That is not given to the President. It is only to be used up during an urgent matter or when an unforeseen event occurs. Next limitation, President can make an ordinance only when he is satisfied that the circumstances exist that makes it necessary for him to take immediate action. Now this statement that he is satisfied, it is a very open-ended condition. Open-ended in the sense, in this case, we do not have a fixed set of pointers. Fixed set of pointers in the sense, we might be having a checklist that is situation A, yes, met. Situation 2, met. Situation 3, met. All three are checked. So yes, now President can issue an ordinance. But that is not this statement says. It says only when he is satisfied. Now with this statement, it is like giving President an uncontrolled measure of power to issue an ordinance whenever he wants, because it is his satisfaction and we do not have any other condition. So in 1970, in the Cooper case, Supreme Court held that President's satisfaction can be questioned in a court on the ground of mala-fide. Now what is this ground of mala-fide? That is on the ground that President has prorogued one house or both the houses of Parliament deliberately with a view to promulgate an ordinance. Now have we seen this prorogued term earlier? Yes, while covering the topic on Parliament, I have discussed three terms. One was adjournment, which means dismissing the existing sitting. Second was prorogue, which means terminating the entire session. And session is a series of sittings which goes on few months. Then the third term was dissolving, that is terminating the entire Lok Sabha, dissolving the entire house. So here we are using the term prorogue because here we saw that when Parliament is not in session. So since it is about session, we have used the term prorogue. Now coming back to this ground of mala-fide, the statement says that President can deliberately prorogue a session. Now we have seen that adjournment, prorogue and dissolution, all these three are done by President. Now since he has both the powers which are associated with ordinance, to issue an ordinance, that is with the President's satisfaction. Then second is prorogue a session, that is also done by President. So when he has both these powers, he can deliberately prorogue a house or both the houses of Parliament because he wants to issue an ordinance which is of controversial in nature. And he knows that if this subject is proposed in the House, it would not be passed by the House and it would not go on to become a law. So in order to bypass the entire parliamentary decision, he can circumvent the Parliament and he can do so by issuing an ordinance. This is not to be done and it can be questioned in the court. This was given by Cooper case 1970. Now remember this case as well because in prelims they ask you such kind of questions. Cooper case, this case is related to which of the following? And you will have ordinance as one of the option and that is your correct answer. That is what you are supposed to tick. So Cooper case 1970 ordinance. Remember this much. Then the 38th Constitutional Amendment Act of 1975. This was 1970. This is 1975. Now one more thing that you need to keep in mind is that there is an ongoing tussle that keeps on happening between the courts, that is the judiciary and the Parliament. So that is happening here as well. So when this judgment was passed by the Cooper case in 1970, in 1975 Parliament enacted 38th Constitutional Amendment Act. And what did this say? It made the President's satisfaction final and conclusive and beyond judicial review. That is, President's satisfaction when it comes to ordinance is final and it cannot be questioned in the court. That is, it is beyond the judicial review. But this provision was deleted by the Parliament itself, but by a separate government. And this was done in 1978 by 44th Constitutional Amendment Act. So what is the present status? President's satisfaction is justiciable on the grounds of malefied, that is, it can be questioned in the court. So here we get a second limitation, that is, President can issue an ordinance only when he is satisfied. And what is the judiciary saying? The judiciary as well as the Parliament by the 44th Constitutional Amendment Act says that President's satisfaction is justiciable, that is, it can come under the judicial review on the grounds of malefied. Next limitation, President's ordinance making power is coextensive as regards all matters with the law making powers of the Parliament except duration. Now this cannot be taken as a limitation. In fact, too much substantial power has been given to ordinance. It is just a temporary law, but still you can make laws on every subject. It is coextensive with the law making power of the Parliament. So it is not actually a limitation. It is actually a positive aspect of ordinance, that you can make law on every aspect which can be touched upon by Parliament. So an ordinance can be issued only on those subjects on which Parliament can make laws. This is the language, but instead I think you should read it in this way. An ordinance can be issued on all the subjects on which Parliament can make laws. An ordinance is subject to the same constitutional limitation as an act of Parliament. That is, ordinance cannot abridge or take away any of the fundamental rights. Again, you should read that it is only fundamental rights which cannot be touched upon by the ordinance, except that everything else can be done by the ordinance. So here we get to know that the ordinance making power of President is exactly similar to the legislative power of the Parliament, except the duration. Next, the fourth limitation. Every ordinance issued by the President during the recess of Parliament must be laid before both the Houses of Parliament when it reassembles. We have already seen that President issues an ordinance because one of the houses or both the houses are not in session. That is one thing. Second, we do not have time to debate and for both the houses to approve it and then President to approve it. So all these things will take time. That is the reason we have this ordinance system. So when the Parliament reassembles, that is when both the houses reassembles, President has to put before them the ordinance. Now after doing that, there are few scenarios which will take place and we are going to discuss all of that scenarios. First one, if the ordinance is approved by both the houses, it becomes an act. Now we have seen that we need both the houses to make a bill into an act or into a law. Similarly, we need both the houses. So when both the houses approve the ordinance, it will become an act. Very simple. This is the first possibility. Second, if Parliament takes no action at all, the ordinance ceases to operate on the expiry of 6 weeks from the reassembly of the Parliament. Ceases here means it will stop or it will not exist anymore. So what is this saying? If Parliament doesn't take any action for a period of 6 weeks. Now Parliament in the sense again both the houses. So if both the houses do not take any action for a period of 6 weeks, it will automatically expire, that is it will cease to operate. The ordinance does not exist anymore. Third possibility, the ordinance may also cease to operate even earlier than the prescribed 6 weeks. Here we have seen that if the Parliament doesn't take any action, we will have to wait for 6 weeks and only after a period of 6 weeks we can say that it has expired, the ordinance has expired. But if the Parliament takes an action and it decides that it will disapprove it, then it will cease to operate, that is the ordinance will become invalid even before the period of 6 weeks. Now we have been discussing about 6 weeks. So here it is made clear how this 6 weeks is to be calculated, because we know that we need both the houses to disapprove it. We need both the houses to make it an act. So in case both the houses, the two houses are summoned on two different dates, how is this 6 weeks period to be calculated? So the period of 6 weeks is to be calculated from the later of those dates. Suppose Rajya Sabha was summoned on 1st of July and Lok Sabha was summoned on 9th of July. In that case, we are going to take into consideration 9th July and we are going to count the 6 weeks from 9th July onwards. This means that the maximum life of an ordinance can be 6 months and 6 weeks in case of non-approval by the Parliament. Now this was a preliminary question. This is a very important statement because it has already been asked in UPSC. Now how is this calculated? 6 months is the maximum difference between two sessions. This statement we are going to see in detail in the future classes. As of now, just understand that the maximum gap which is allowed between two sessions is 6 months. So this is the maximum gap. This is one thing. Second thing is that when both the houses of the Parliament decide that they do not want to take any action regarding the ordinance, after a period of 6 months, the ordinance will expire on its own. So what is the maximum life of ordinance here when both the houses reassemble? It is 6 weeks. So after reassembling, it is 6 weeks, and before reassembling, the maximum gap that is allowed between two sessions is 6 months. So that is how we have calculated this 6 months and 6 weeks. If an ordinance is allowed to lapse without being placed before Parliament, then the acts done and completed under it before it ceases to operate remain fully valid and effective. That is, the ordinance was not placed before Parliament and it was allowed to lapse. In that condition, when the ordinance lapses, that is when it becomes invalid, the actions which were done under it, it will remain valid and effective. So the actions which were done before the ordinance became invalid, those actions will still remain valid. So this is what this statement says. So once again, very quickly, ordinance has to be placed before the Parliament. If they approve, it becomes an act. If they do not take any action, it will expire after 6 weeks. It can expire even before 6 weeks if they disapprove it. And how this 6 weeks is to be calculated is given here. The later date has to be taken into consideration. Then if it was allowed to lapse, the previous actions will still remain valid and effective. The President can also withdraw an ordinance at any time. Here we saw the scenarios that can take place when the President places the ordinance in front of the Parliament. But here what are we discussing? That he himself can withdraw an ordinance at any time. But this power of ordinance making is not a discretionary power, and he can promulgate, that is issue or withdraw an ordinance only on the advice of the Council of Ministers headed by Prime Minister. Now this is like most other situations where he is not allowed to take a decision by himself. Instead, he has to go by the decision which has been given by the Council of Ministers. So that means he will have to act according to the advice of the ministers. So promulgation he cannot do by himself. Withdrawing he cannot do by himself. Although we have seen that President can make an ordinance only when he is satisfied. Now this satisfaction is not his own satisfaction. Instead, it is the satisfaction of the Council of Ministers headed by Prime Minister. So only with their advice he can promulgate an ordinance. Now there are few pointers which are given. An ordinance, like any other legislation, can be retrospective. That is, it may come into force from a back date. Now suppose I am the President and I am issuing an ordinance that any NGOs which are dealing with children, they will have to go through a series of background checks. Now these rules are not valid only for the NGOs which are going to come up in future, but I say that this law is applicable from 2014. That is, all the NGOs which have been set up after 2014 will have to go through all these background checks. So that means the ordinance is retrospective. Although it was issued in 2022, it can affect an NGO which had been existing since 2014. So that is the meaning of retrospective. Second, it can modify or repeal any act of parliament or another ordinance. So that means it can make some changes in the already existing law, or it can make some changes in the already existing ordinance, or it can take back the law. Suppose there is a law which was passed by parliament. Now the president can issue an ordinance and say that the law which was passed by parliament, that doesn't exist anymore. So an ordinance can repeal a law which was made by parliament. Third, it can alter or amend a tax law. So all these things can be done by ordinance. However, it cannot be issued to amend the constitution. That means ordinance cannot change the constitution, though it can change a lot of things. It can change the law made by parliament. It can change another ordinance. It can make a legislation which is retrospective. It can change tax laws, but not the constitution. Next, the ordinance making power of the president in India is unusual and not found in most of the democratic constitutions of the world, including that of USA and UK. Now in the previous Polity video, we were discussing the election of the houses, and in that we saw that most of the aspects were similar to that of UK but were entirely different from USA. But when it comes to ordinance, it is different from that of USA as well as UK. Because in these two countries, we do not have anything called ordinance or anything similar to that of ordinance. Now justifying this in the Constituent Assembly, Dr. B.R. Ambedkar said that the mechanism of issuing an ordinance has been devised in order to enable the executive. Who is the executive? We have discussed, they are the ministers, the elected ministers. So it is for them to deal with a situation that may suddenly and immediately arise when the parliament is not in session. That is the reason we say that an ordinance which has been made when the parliament is in session is void in nature. Because this power has been given to deal with the scenario which arises when the parliament is not in session. This was the true purpose of ordinance when it was designed by the Constituent Assembly originally. Further, it has no connection with the national emergency. Here we saw that it is to deal with a situation which arises suddenly. But that doesn't mean that it is only for the national emergency or it is related to the national emergency. President can issue an ordinance even when there is no war or external aggression or armed rebellion. That is, it is not necessary that only in these scenarios he is allowed to promulgate an ordinance. An ordinance can also be promulgated in some other situation as well. The rules of Lok Sabha require that whenever a bill seeking to replace an ordinance is introduced in the House, we have seen that whenever the House reassembles, President has to place the ordinance before them and that ordinance will have to become a law. So whenever it is placed in front of them, it is in the form of a bill, and when they approve it, it will become a law. So when he is placing it in front of them, a statement should also be placed. Now what is this statement? It should explain the circumstances that had necessitated immediate legislation by means of ordinance. That is, what was the reason? Why did you issue an ordinance? That explanation has to be given in this statement. What was the urgent need? So this should also be placed in front of the House. Now who says this? Is it given in the Constitution? Does the Constitution ask you to do so? No. It is a mandate given by the rules of Lok Sabha. So you might get a question in your prelims which says that as per the Constitution of India, the President needs to place a statement which explains the reason behind promulgating an ordinance. Now this statement is partially correct, partially incorrect. Yes, he has to give a statement explaining the reason, but it is not mandated by the Constitution. It is mandated by the rules of Lok Sabha. So this thing you need to note, rules of Lok Sabha require him to do so. So far, no case has gone to the Supreme Court regarding promulgation of ordinance by the President. We have discussed many pointers regarding ordinance, that is, it can be made only during the recess of Parliament, then it is temporary in nature, then it can do only those things or make only those changes which a Parliament can make. The rules of Lok Sabha state that whenever the House reassembles, the President will have to give an explanation statement regarding the promulgation of ordinance. So in case things go wrong in any of these aspects, it will go to the judiciary. But till now, no case has gone to the Supreme Court. But Supreme Court has suo motu given some statement, given some judgment with respect to the ordinance. And what was that? It was DC Wadhwa case of 1987. Again, very important statement and a very important potential question for your prelims. So the question could be, DC Wadhwa case of 1987 is related to which of the following? And one of the option could be ordinance, and that is your correct option. You are supposed to tick that option. So DC Wadhwa case, ordinance. So in this case, the Supreme Court pointed out that between 1967 to 1981, the governor of Bihar has promulgated 256 ordinances. This is like having his own another set of constitution, and that is not allowed. And all these ordinances were kept in force for a period ranging from 1 to 14 years by re-promulgation from time to time. Now this is also not allowed. We have seen that ordinance is temporary in nature. It is not like the law made by the Parliament. It cannot go on to exist forever. So the time period is also something which is not valid. So the court ruled that successive re-promulgation of ordinance with the same text without any attempt to get the bills passed by the assembly. Now this statement, this can also be used as a loophole. We know that such kind of loopholes are used even by the pharma industry. We know that when the pharma companies are applying a patent on a medicine, they are allowed to patent it only for a specific duration. So what are they doing? After that duration, they change the chemical composition of that medicine, and they are changing it in only a minor way, in such a way that it is not going to affect the efficacy of the medicine. So what is happening? The medicine remains the same. There is no major change, but yes, they can say that the composition is different. So what have they done? Stating the reason of a different chemical composition, they are extending their patent. They are patenting it once again, and they are not making it available for the masses. They are keeping it for themselves and making their own profit. So the same thing can happen here as well. When they say that with the same text, they can make some minor change with the text and keep on re-promulgating the same ordinance. So we should also be more careful and see to it that they do not use any loopholes. So coming back to the judgment, the court ruled that successive re-promulgation of ordinance with the same text without any attempt to get the bills passed by the assembly would amount to violation of the constitution, and the ordinance so re-promulgated is liable to be struck down. So that means judiciary can strike down any law which is unconstitutional in nature, which is not agreeing with the constitution which was framed by the Indian constitutional makers. So anything which goes against it can be struck down by the judiciary. Further, the judgment said that the exceptional power of law making through ordinance cannot be used as a substitute for the legislative power of the state legislature. That is, it cannot act as a parallel government. We had already seen that the two cannot exist together. Only when the parliament is in recess, the president is allowed to make an ordinance, or the governor is allowed to pass an ordinance. Otherwise, both cannot exist together. So the point to be taken from here is, if you get this statement that no case has gone to Supreme Court when it comes to the promulgation of ordinance, yes, it is a true statement. But if the statement is Supreme Court or the judiciary has never commented about the misuse of ordinance, that is a wrong statement. Judiciary has commented about the misuse of ordinance in DC Wadhwa case of 1987. So that's all from my side for this video. I'll be back with the next video very soon. Thank you so much.